Hi, this is Lee from the Law School Toolbox. Welcome to Listen and Learn, Applying Law to Facts, the practical companion to our rule review video. In this episode, we're taking the legal rules we've learned and applying them to real-world scenarios. This video is about Civil Procedure Rule 12b-6. This is your opportunity to test your understanding and enhance your legal reasoning skills as we work through various fact patterns together. If you haven't watched our rule review video yet, we recommend checking it out for a comprehensive overview of the rules. It is linked in the show notes. Let's examine a few hypos to sharpen our understanding. Farm P enters into a written contract with Company D for the sale of tractors. Under the terms of the contract, Farm P will pay Company D $100,000. And within 30 days of Farm P's payment, Company D will deliver 5 tractors to Farm P. Farm P paid Company D the $100,000, but after 30 days passed from the time of that payment, Company D failed to deliver any tractors to Farm P. A few months later, Farm P filed a complaint in federal court against Company D, alleging a claim for breach of contract. The elements of a claim for breach of contract are 1. A contract between the parties, 2. Performance by the plaintiff or excuse for non-performance, 3. A breach or failure to perform by the defendant, and 4. Damages to plaintiff as a result of the defendant's breach. In its complaint, Farm P provides the following allegations to support its claim for breach of contract against Company D. Farm P alleges Company D had a contract with Farm P performed its obligations under the contract, Company D breached the contract, and Farm P suffered damages as a result of the breach. In response to Farm P's complaint, Company D files a Rule 12b-6 motion to dismiss the complaint for failure to state a claim. Should the court grant Company D's motion? The answer is yes. Farm P's complaint only contains legal conclusions and not any factual allegations. The allegations in the complaint merely recite the elements of a claim for breach of contract and assert that those elements have been met. But Farm P does not provide any specific facts in the complaint showing that it is plausible that the elements have been met. For example, Farm P asserts in a conclusory manner that Company D breached the contract. But Farm P does not provide any factual allegations demonstrating that this is plausible. Farm P does not explain in the complaint the terms of the contract it had with Company D and how Company D failed to meet its obligations under those terms. In sum, because Farm P's complaint only contains legal conclusions, and legal conclusions unsupported by factual allegation are insufficient to properly state a claim for relief under the Twombly Iqbal standard, the court should grant Company D's Rule 12b-6 motion and dismiss Farm P's complaint for failure to state a claim. Continuing on with our hypo, the district court grants Company D's Rule 12b-6 motion to dismiss, and the court dismisses Farm P's complaint with leave to amend. Farm P then files a first amended complaint that contains the following allegations. In fall 2023, Farm P entered into a written contract with Company D for the sale of tractors. Farm P performed all of its obligations under terms of the parties' written contract. Company D breached the contract by never delivering any tractors to Farm P, and Farm P suffered damages as a result of Company D's breach. In response to Farm P's first amended complaint, Company D files another Rule 12b-6 motion to dismiss the complaint for failure to state a claim. Should the court grant Company D's motion? The answer again is yes. Now this time, in the first amended complaint, Farm P does provide some specific factual allegations, and not just legal conclusions to support its claim for breach of contract. For example, Farm P's allegations that it had a written contract with Company D for the sale of tractors and that Company D breached the contract by failing to ever deliver any tractors are factual allegations and not just mere legal conclusions. But the problem here is that Farm P does not provide factual allegations for all the elements of its claim for breach of contract against Company D. In order to properly state a claim for relief, the plaintiff must provide factual allegations showing that it is plausible that all of the elements of its claim have been met. In the first amended complaint, Farm P only provides a legal conclusion for the second element of its claim for breach of contract. Farm P simply alleges that it performed all of its obligations under the terms of the parties' written contract, without providing any specific factual allegations to support that assertion. That is insufficient to meet the Twombly-Iqbal standard, and because Farm P failed to provide sufficient factual allegations as opposed to mere legal conclusions for all of the elements of its claim for breach of contract, the court should grant Company D's Rule 12b6 motion and dismiss Farm P's first amended complaint. Returning back to our hypo, the district court grants Company D's Rule 12b6 motion to dismiss, and the court dismisses Farm P's first amended complaint with leave to amend. Farm P then files a second amended complaint. The second amended complaint contains all the allegations that were in the first amended complaint and also includes the following new allegations. Under the terms of the parties' contract, Farm P would pay Company D $100,000, and within 30 days of Farm P's payment, Company D would deliver 5 tractors to Farm P. Farm P paid Company D the $100,000, but several months have gone by since that payment, and Company D has still never delivered any tractors to Farm P. Farm P has been damaged by Company D's breach because Farm P made a monetary payment to Company D and never received anything in return for it. In response to Farm P's second amended complaint, Company D files another 12b6 motion to dismiss the complaint for failure to state a claim. Should the court grant Company D's motion? The answer here is no. The new allegations in Farm P's second amended complaint remedy all the defects from its prior complaints. This is because in the second amended complaint, Farm P provided specific factual allegations for all 4 of the elements of its claim for breach of contract. For the first element, Farm P explains that it had a written contract with Company D for the sale of tractors and explains the material terms of that contract. For the second element, Farm P explains that it performed under the contract by making the required $100,000 payment to Company D. For the third element, Farm P explains that Company D breached the contract by failing to deliver any tractors within the specified time period. And for the fourth element, Farm P explains that it suffered damages because it made a payment to Company D and never received anything in return. Because Farm P has provided specific factual allegations showing that it is plausible that it meets all of the elements of its claim for breach of contract, Farm P has properly stated a claim for breach of contract against Company D, and therefore, the court should deny Company D's Rule 12b6 motion to dismiss Farm P's second amended complaint. And that wraps up our discussion of conclusory pleadings under the Twombly-Iqbal standard for assessing motions to dismiss under Federal Rule of Civil Procedure 12b6. Hopefully you found these hypos helpful examples of how to work through any Rule 12b6 motion to dismiss question on your exam. That concludes our Listen and Learn Applying Law to Facts episode. We hope this practical application has helped reinforce your understanding of how legal rules work in real situations. If you haven't watched our rule review video yet, we recommend checking it out for a comprehensive overview of the rules. Like and subscribe for more Listen and Learn content, and feel free to leave comments with any questions or topics you'd like us to cover in future episodes. Thanks for watching.